Yeah, my name is Laura Trapnell. I'm the IP partner at Trethowans. IP is the only exciting area of law in my view. I am really passionate about my job, what I do, because there's so much value that I can add for free to companies, so that once you start trading in the right way, you can align your IP with commercial strategy, financial forecasts, and all that kind of thing, so that you're protected in the best way that you can. So I also do, it might be of interest another time, Rob, but I also do an hour's workshop on IP generally, different IP rights, and how they're created and who owns them and things like that. I'm not talking about that today. Today's focus is specifically trademarks, I was asked for, so I will do that. Trademarks only. I really don't like, particularly in this Zoom forum, just me talking at you. I'm not sure whether I'll be 25 minutes or an hour and a half. So please do chip in, because it makes it much more valuable, much more interactive if you sort of help me as we go through. I'm just going to share my screen. Oh, now that ribbon is right over my, oh no, there we go. I can do it down there. There we are. So this is going to be our focus on trademarks. So this is what we're going to try and cover today. First of all, what is your brand? Then we're going to look at how your brand is recognised at law. We're going to look at the different types of trademarks that you can apply for. We're then going to look at protection and registration and what that actually means. And then I'm going to actually walk you through the step-by-step process of filing a trademark. And then we're going to talk just a little bit about trademark strategy. And as I say, that'll either take 25 minutes or an hour and a half. So we'll just go with.
It won't take an hour and a half, I can tell you that, Laura.
If I get excited, it might.
It may take us up to 5 o'clock. Can you just hop into full slideshow? We're seeing your edit view at the moment.
Oh, I am in full slideshow on my screen.
Okay, then in that case, you're not perhaps sharing the right screen or the right window.
Okay, let me try again then. That better?
Yeah, that's it. Great.
Okay, thank you. Right. Oops, back one. So, what is your brand? So, for me, your brand is essentially your foundation on which your reputation is based. It's the reason why people come to me at Trethowans, why you've all signed up to a business support hour here, because you know that it's going to be good. And it's your USP which sets you aside and your business aside from other traders in the field which are doing the same thing that you are. So for me, it's all about customer experience, and your specialness that makes people come back to you time and time again. And to me, that's really important. So let's look at sort of how we go about protecting that in the best way that we can. So how your trademark is recognised at law, in legal terms, your brand is called a trademark. So rather ridiculously, we used to have it all as one word. Now it's been changed in the 1994 Act to 2 words. So trademark is now 2 words, and that's the name that it's given at law. So legally, we call it your badge of origin, and under the legislation, that badge of origin distinguishes your goods and services from those of another trader. So trademarks can be registered. If you want to rely on them at law, they now have to be registered. So that little R in a circle denotes a registered trademark. And it's actually a criminal offence for you to use that R in a circle if your mark is not yet registered. So once your trademark is registered, you can use that little R in a circle, usually at the end of the brand and normally in the top right-hand corner. Now, trademarks are renewable every 10 years and they can last indefinitely. So that BAS logo that I put there was the very first trademark that was ever registered in the UK. And it's still on the books today because every 10 years they've renewed it. So when you come round to renewing your mark, the Intellectual Property Office will let you know, or if you've got an agent acting on your behalf, like me, for example, they would let me know that your trademark is coming up for renewal, usually in 6 months' time, and then we can renew your mark for you, pretty much at the same cost that it cost for you to file it in the first place. The IPO, I don't think, have put up their trademarks in most of the time that I've been practicing, put up their fees. So your renewal cost in 10 years will be pretty much the same as when you applied for it. Now, the main thing to remember about registered trademarks are that they are territorial. So you must apply for them in the territory in which you want protection. When we were part of the EU, you could apply for a lovely big EU trademark, and that would cover you in all EU member states. Now, since Brexit, you also have to apply for the UK separately. And so it's worth putting some thought around, where are the key territories that I'm trading? If just the UK, then we just need to focus on the UK. But if you're also trading internationally, then we should put some thought about a sort of strategy around, where do I want to be registered this time next year? You know, there's a budget associated with each different territory. The UK is really quite reasonable in terms of registration fees. Of course, Europe is much higher. America is then much higher again. And then the Far East is out of most people's budget. So sort of pragmatic thinking really about where you want to be registered. So registered trademarks are recognised at law and are protected under our new Trademarks Act of 1994. So for me, this is still a new Trademarks Act, although I think lots of my colleagues were born around that time, so they've only known the 1994 Act. If you don't register your trademark, it can still be protected, but it is not protected at law. It would be protected under common law and the right of passing off. So if you have an unregistered trademark prior to the new 1994 Act, they were recognised at law, but the 1994 Act did away with protection for unregistered trademarks, and now you have to rely on passing off. So you can use that little TM symbol there, again, usually at the end of the brand in the top right-hand corner. And that TM symbol denotes that you have an unregistered trademark. Now, I would say about 90% of the business population still believe that that TM symbol means something. So my view is always, you know, why not use it? It doesn't actually give you any rights at all, other than telling third parties that you treat this mark as a trademark. But it's completely for free. It shows that you're sort of IP aware. And if you don't have the budget for getting a registration, then using that TM symbol can often be very useful. So the TM symbol protects your reputation, if you like, and so you could be limited geographically. If you are only trading in the south, for example, within Hampshire and Dorset, and someone uses your unregistered trademarks up in Newcastle somewhere, then unless you have a reputation that extends into that territory, passing off can sometimes be very difficult. So if you are able to register your trademark, then that is absolutely the way to go. In terms of what we can protect, there are all sorts of different types of trademarks. So the strongest form of protection that you can get is simply a word mark. So I've used Coca-Cola here because that registration of Coca-Cola without any visual element to it at all is the strongest form of protection, because it will stop anybody from using an identical mark on identical goods, an identical mark on confusingly similar goods, or a confusingly similar mark on confusingly similar goods. So there's 3 different layers of protection that you can have with a trademark once it's registered. But that word mark is absolutely the strongest form of protection. Now, in order to get a word mark like that, your trademark has to be distinctive of the goods and services that your business offers. So if you have a descriptive trademark, that is going to be much more difficult to register because it might well contain words that are either geographical or descriptive, and therefore they lack distinctiveness when it comes to designating your goods and services. So the IPO would have a fundamental objection called an objection under absolute grounds if your trademark is descriptive and not distinctive. Now, there are ways that we can get around a descriptive trademark, and primarily they look at a 5-year trading history and whether in that 5 years the use that you have made of that descriptive mark has been such that that mark is now synonymous and associated with your own goods and services. So that's a word mark. Another way that you can add distinctiveness to a descriptive mark is to put some sort of stylization with it. So a stylized mark like the second one here. So that's the Coca-Cola logo. It's still the word Coca-Cola, but it's in a figurative form that they also then want to protect. So for Coca-Cola, for example, even though the words are so important, so is also that stylization. So if someone brought out a fizzy drink saying, I'm, Coca-Cola or something like that, that probably would still infringe the word mark, but they might, for example, use a different word, but still in that figurative font, and they would want to stop someone there as well. So they would have applied for both of those marks. And then you can apply for a figurative mark, which has no wording in it at all. So if your logo is as important as the wording that you use, the name of your brand, then you can also apply for a logo mark, a figurative mark, like Apple has done there. In the 1994 Act, it brought in the ability to apply for unusual trademarks, and we've got colours that you can now apply for and shapes. So we've got purple, this colour purple, not actually this Pantone, but a specific Pantone of purple registered in relation to cat food, which is, of course, whiskers, and also registered in respect of chocolate. And we have, you will probably have heard of the never-ending disputes between Cadbury's and Nestle as to who owns the purple chocolate colour. So that goes on and on and on. There's yellow registered in respect of roadside recovery services for the AA. And then orange, I'm not sure if it's still registered now, but was registered in respect of mobile phone services. And then the 1994 Act also brought in the ability to register shapes. So I was working up in London in 1994, and we had lots and lots of drinks companies registering all of their bottle shapes as trademarks. And it was a real thing back in 1994. There was an absolute plethora of them. And now as the law has kind of trundled through, and we're now 30 years later, rather than 20, 30 years later, that shape marks are now very much out of fashion, and we've gone back to relying on registered designs for shapes rather than brands. And then, of course, it also brought in sounds. So direct line registered there, so that's registered in respect of their services. So those are the different types of trademarks that you can register. When it comes to protection, trademarks, as I've said, need to be registered in the territories where you want to be protected. So if you are going to register your marks, you really must consider all of these things before you sort of embark on the journey. So budget, we need to be aware of what the lifetime costs are going to be. So they're renewed every 10 years, and that's the same in each territory. So if you're renewing this year in the US and next year in the UK and the next in the EU, it's really important that you build in that budget to your financial forecasting. With new territories, again, plan accordingly. If you know that in the end, by 2 years' time, you're going to be trading in Europe, then we already need to be thinking about protection in Europe, because we need to carry out freedom to operate searches to make sure that we're not treading on anyone else's toes. We used to spend huge amounts of time doing trademark searches through Thomson Reuters and Clarivate and all this kind of thing, and massive great Bibles would arise with sort of similar marks, confusingly similar marks on identical goods and all of this, and we trawl through them advising clients. We now just actually do Google searches, because Google is such a good search tool that if someone is using something similar to your brand, it will almost certainly come up. So Google is your friend. Carry out freedom to operate searches before you start filing your trademarks. Think carefully about your filing strategy. You know, where is your key territory? Where do I want to be in 2 years' time, and what budget do I need? And then use the TM and R symbols appropriately. As I say, the R symbol only once your trademark is registered, but the TM symbol, most people think means is a registered trademark, so why not use it? If you don't go down the registration route, then I've already said that an unregistered mark can be protected by common law and the right of passing off. Passing off is a really difficult action to bring. You have to show these 4 points. So first of all, you have to show that you have a reputation, and it's a reputation that's big enough and strong enough to protect you where the potential infringer is. You then have to show that the infringer is attempting to trade off that reputation and present in the marketplace in association with you. You then have to prove that there is confusion in the market and or a likelihood of association, and that as a result of all of those things, you are suffering damage. Now, that's usually in terms of diverted sales, but it can also be in respect of damage to your reputation if the person who's passing off is using the mark to your detriment. So much easier to smack a trademark certificate in front of somebody, albeit that we're wary of threats, because there's threats legislation that stops you bullying or unnecessary bullying. But that is much easier to prove and establish than if you are trying to establish a passing off action. So when it comes to actually filing our trademarks, let's think very carefully. What are we going to protect? What is most important to you? Is it the name? Is it the stylized version of the name? Or is it a logo? Because all three are separate trademarks, and all three are beneficial in their own right. So remembering that a registered mark will protect you against use of an identical mark on identical goods or services, but also a confusingly similar mark on confusingly similar goods and services, or an identical mark on confusingly similar goods and services. So you have to have a think about, what is it that I'm trying to protect? Is it the way that the word is spoken? Is it the way that the word looks? Or is it a separate logo? Then we choose our, is someone ask a question? No. Then we choose our territory, probably the UK first and foremost. And if we then want to expand internationally, it's possible to do that through the World Intellectual Property Organization, which uses the Madrid Protocol system, where you can use your UK registration as a base to then sort of stepstone around the world, choosing different territories, which then are based back on your UK registration. Before you file, as I say, carry out a freedom to operate search, because otherwise you might have a very costly rebranding exercise immediately prior to launch. It sounds ridiculous, but I've actually just had quite a large client of mine launch a new product, and they've asked me to carry out a search now that they've received a cease and desist letter, and there's an absolutely identical mark on identical goods. And had they asked me to carry out that search before they launched, they could have saved themselves a lot of time and effort and legal fees. And then, of course, think about putting aside some funding for brand enforcement, because trying to stop third parties from using an identical or confusingly similar mark sometimes arises without malice. You know, people sometimes just choose the same name, and so legal letters are required. Please be very, very careful about threatening trademark infringement if you're not really, really clear that you're doing so within the parameters of the law. There's a new, or 2017 actually brought out an IP threats piece of legislation which makes it illegal for you to threaten trademark infringement action against certain traders without having justifiable cause for doing so. So what we tend to do is sort of alert people to the fact that they're using a mark which is either identical or confusingly similar to your own. And that first letter is always, you know, I'm sure it's inadvertent, but here's my trademark registration, and you might want to rebrand. And if they come back and say no, that's when you get the lawyers involved. I'm going to walk you through actually how you go about doing it. So in the UK, we have the lovely Intellectual Property Office based in Newport in Wales, and they really are super nice and helpful, particularly if you are an individual filing a trademark. You can call up their hotline and they will do what they can to help you get it right. So the URL is there, ipo.gov.uk, and away we go. So this is the very first screen that you get to when you apply to register the trademark. And what it's asking is, who is completing this application? Are you the trademark owner or a person within the business? Or are you, like me, an attorney, solicitor, or in-house trademark team or third-party representative? So when I file trademarks on behalf of a client, I tick that box. You would be ticking the first box, and then you click continue. Now you'll see on the next page, and every single page that goes after this, there's a back button on the IPO's website, and that is the button that you use to navigate between your screens. If you use the back button at the top of the web page, you know, your browser, then you will lose all the history that you've done to date. So if you're wanting to go back within your trademark application, do use that little button. And then this is the second screen, and what it's asking is, are you really sure that you're ready? Have you checked whether someone has already got a similar trademark? And have you checked your trademark against the assessment criteria? So it will look at things like, how distinctive is your mark? Are you using anything which is descriptive? And it has a link there to check whether or not it's registrable. And then you press continue. It then brings you to this screen, which is where you fill in your details. If you already have a trademark registered, you would click on retrieve your name and address, and you just put in your details and it will bring up your ID number, which you've already got. And if it's your first one, then you would add your name and address details and then continue. All the way through, it gives you a save for later option. And if you do click on that, it just keeps everything that you've done to date and sends you a link so that you can access it at a later stage. So then this is the form that you get next, where you're adding your own details. You add in the owner type, so that says individual, company, partnership. You would fill in these details here. And then the IPO is very clear since GDPR about what it actually does with your email address. Now, I would be extremely wary about providing telephone number or email, because this is going into the open system, so anybody internationally can look at your personal name, your address, your telephone number, and your email if you filled all of that in. There is no requirement to fill in telephone or email. But this is where having a third-party representative is often very useful, because I fill in that as being the Trethowans address. So I've identified the owner, but all of my clients are care of Trethowans, because there are unfortunately loads and loads of trademark scams. Those of you with registered marks will probably already have received them, where as soon as this information is published, you get fake invoices from third-party scammers saying your trademark's about to be registered, please send, you know, something exorbitant like £3,000 to this address. And the same happens near to renewal. So Fiona, I think it might have been you that said, or Caroline, whoever's trademark is coming up for renewal next year, be aware you will get scam emails saying renew it through us, renew it through us. The only correspondence that is valid will come directly from the Intellectual Property Office, or if you have a third-party agent acting on your behalf like me, it would come through me. So don't apply for anyone else at all. And if you do get them through, please do send it over to me and say, Laura, is this a scam? And I can tell you straight away just from looking at it whether or not it is. So we tick this box. I understand that the IPO will use my email as described above. If I've not filled in my email, I don't bother putting that. And again, I understand that the name and address will be published. Then it asks you to declare that you are entitled to hold the property. And that's then their sort of checks and balances, if you like, that you are not applying for Coca-Cola or for Trethowans or something like that, when actually you're not entitled to do so. So then we come onto this screen, which is what sort of trademark are we applying for? Are we going for words only, as in beehive? Are we going for a logo only without any words? Or are we going for a combination of the two? And or is it an unusual type of trademark, like a sound mark? And so we would pick here whatever it is that we're going for. We've already made the decision, are we going for a word mark or a stylized mark or a logo? And so you just tick the appropriate box and press continue. Then it asks us, are we applying for a single trademark or a series of trademarks? 99% of the time you will be applying for a single trademark. A series of trademarks is when there is very, very minor changes between the different versions of the trademark that you're applying for. So sometimes, for example, if I'd been filing that stylized version of Coca-Cola in red, and they wanted it in green and they wanted it in blue, we would be able to get that through on a stylized series of marks. Rather than file separate trademarks each time, we could get all of those through on a series mark. They, I think, cost £50 more than a single trademark, but rarely do you use series. So you would tend to click single trademark and continue. And then this is the tricky bit. So you have to choose which goods and services you are applying to protect. There are 47 classes now, I think, of goods and services, and essentially you need to slot yours into the right class. So for us, legal services is, I think, class 45. I'll show you in a minute because I did it whilst I was doing this talk for you. Software is class 9. Books and things like that is class 16, clothing is class 25. So you have to then slot your goods and services into the right category, and I will show you how we do that in a moment. This then says if you're doing a standard trademark, it's £170. and then £50 for each additional class that you want. So, for example, Trethowans, we do legal services, and that's our primary class. But we also host events and we also do training. So we apply in at least 3 classes. I would say don't bother applying for absolutely everything. So years ago, again, when the 94 Act came through, Trethowans, we would have applied for branded clothing. We would have applied for caps. We would have applied for pens and pencils and mints and notebooks, all the stuff that we give out at seminars. So what you're doing here is you're not protecting absolutely everything that you put your mark on, but you are protecting the key services, goods that you actually provide under that brand. So these are your options for when you are choosing your classes. The first is you select it from a pre-approved list of terms, and we'll look at that. Or you can select the class and enter the terms manually, or you can copy it from an existing trademark. I'm going to look at each of those with you now. So if you're selecting from a pre-approved list of terms, what you do is you type your goods or services into here and press search. So I put in legal services and it said it's class 45. And then it gives you various different ways of saying legal services. So I could click legal services, I could click attorney, I could click conveyancing, bailiff, legal consultancy. And all of those, once I've clicked them, appear in my selection. So that's one way of doing it. The other is that I could select the class and add it manually. So this is what I tend to do because I know what I'm doing. So in which case I would select class 45 and I would write in the services that I want to protect. But this one is really only to be used when you absolutely know which class you're in and what terminology you want to use. Otherwise, I really would recommend that first one where you put in what you want to protect and it gives you the class and it gives you a variety of phrases to use. The other one is copy it from an existing trademark. So, for example, with Trethowans, we've got the plain word mark with no stylization, and then we've got a stylized form of our trademark. Now, I don't want to go through this form every single time I file a trademark. So what I do is I get to this page and I put in the trademark that I've already got, which was 3457645. It's registered in the UK and I press continue. And then it brings me up my existing Trethowans mark. I then click which classes from that mark I want to replicate. I just decided on the first one, but I might want to do all of them. And it's just a shorthand way of applying to register your mark. So once we've done whichever way we're going to do it, we've chosen our goods and services, we've got our class, it gives you a summary, and it then tells me how many additional classes I've got and what my additional fee is going to be. So I've added one more class. So your first class is £170 and each additional class after that is 50. So I've added one more additional class, so I've got another £50 to pay. So before I proceed, it then tells me that once I've submitted my application, the IPO is obliged to tell existing trademark owners if there is something confusingly similar on the register. So if one of you were to apply to register the mark Trethowans for legal services, and despite the box at the beginning which says, are you entitled to hold this property, you'd clicked yes. When your application goes through, because I have a registered mark for Trethowans and the IPO think that it's confusingly similar, they would let me know and then I would have an opportunity to object. So this is just a kind of warning page which says, you know, if you select too many goods and services, you might start to tread on people's toes. But there's a fine line between, actually, I only want to apply for this trademark once, so I'm going to cover as broad a range as goods and services as I possibly can, compared to, clearly, the wider the breadth of your goods and services, the more likely you are to actually step on someone else's toes. There's a requirement that you use your trademark on the goods and services that you have chosen to protect within 5 years from the date of application, because otherwise the mark could be vulnerable to revocation through non-use. So you must use your mark within 5 years. You then tick the box at the bottom that the trademark is being used by the owner or with the owner's consent, and that there is a genuine intention to use the mark on the goods and services being applied for. We then get to these screens, which are a little bit complicated. So the first one says, do you want to apply a disclaimer? And then it says 99% of trademark applications do not need a disclaimer. So a disclaimer is something like, if I applied for Trethowans legal services, I should disclaim legal services, because that is not part really of my brand, and they are descriptive terms that other traders would legitimately want to use. So I don't want that to be really part of my trademark. But normally you don't want that. You want to protect the whole trademark, so you would click no. The next screen then says, did you have a pending international application before 31 December 2020? It's all part of the transitional arrangements for leaving the EU. And basically that's to do with, if you had already applied for an EU mark that wasn't yet granted at the time that we left the EU, you can carry it across to be a UK application. So mostly you would click no and then continue. Do you want to claim a priority registration date? Again, most of us would click no, because we haven't applied for a trademark outside of the UK within the last 6 months. But if you have, so for example, you have applied for an EU mark and you want to claim the priority date, then you would tick yes, and you would then fill in on the next screen the office and county of origin, the application number of your international mark, and the date on which it was filed. So then it says, what is this mark? Is it a standard trademark? 99.9% of the time the answer is yes. Or is it a certification mark or a collective mark? Now, in the whole of my sort of 30 years practice, I have applied for one certification mark, which I did for Wines GB. But your New Forest mark is actually, well, I'll ask you actually, Rob, whether or not it's a certification mark or a collective mark. But certification mark is, we have met the approved standards that are required for us to be able to use this trademark. So for Wines GB, for example, you have to have produced the wine in the way that is prescribed by the Wine GB rules and regulations, so that you can then use that mark. A collective mark is more of a badge of membership, like the AA, for example. And I'm not quite sure how your New Forest mark works, Rob. Is it certification or is it collective?
First of all, it's not NFBP's mark. They're a separate CIC, but my understanding is that they provide certification of origin. They don't verify quality, but they verify origin.
Origin. So there we are. That would then be a certification mark. But as I say, 99.9% of the time you are applying for a standard trademark. So the fee can be dealt with in two different ways. You either pay the standard examination fee and you pay the full fee with your application. And it says here, the fee is made up of £170 for the first class and £50 for your second class. Or you can choose to use the right start method, which is where you pay £50 extra but in fact it's £30 extra on this one, it looks like. And then you split the payment in two. So we do this very often if we're not sure that the mark is going to get through. So if I had any doubts that your trademark was distinctive enough or might be refused on some other policy, like FC UK, you know, that was a very clever branding initiative. But you could apply for it under the Right Start examination process, and then you only pay half up front. They then examine the mark and give you their response, the IPO, and if it's positive and you want to proceed, you pay the remaining 50% and move forward. But there is a small uplift for doing it that way. But very often, if you're applying for a mark in lots of different classes, and your fee is quite substantial, doing it right start and being really sure that it's going to go through is a good way of doing it, and only paying half the fees up front. So we then get to renew the entire application. So all the things that you filled in, like the owner details, the representative details, what's being applied for, your goods and services, the fee, you have a good opportunity to really check it very carefully. As soon as it's submitted, you cannot change it. You are able to withdraw things. So I could, for example, withdraw legal services, but I can't add to it. So it's very important that this is absolutely right. Very often, save for later. You know, if you're in a hurry, don't file it now. Save it for later. Go back and have a look at it. And then your very last page is your legal declaration, if you like. Yes, I'm entitled to hold this property. Yes, the terms of the goods and services should be given their ordinary and natural meaning that, you know, I've done one recently where the infringer has tried to file an identical trademark to my client's trademark by using the word tent instead of chamber. And we've got huge opposition proceedings running through the IPO, and I'm challenging it on all sorts of basis, but one of them being that you're not giving the term its ordinary meaning. You know, this is not a tent in its sort of camping ordinary meaning in any way, shape or form. It's a zipped up, you know, clear chamber that if you were camping in that, you'd be a bit embarrassed. So, and then thinking that you understand that once the mark has been, the application has been filed, it cannot be changed. And then you add the declarant name, a contact name, and a reference if you want to. How do you make payment? By credit card, ideally. We have a deposit account with the IPO, so I usually tick that box, but usually by payment or debit card. And then your application is submitted. And that's the email that you get back at the end of the day. That will then be your new trademark number going forwards. And once payment is cleared, it will start the examination process. Now, the examination process in the UK takes between 4 and 6 weeks. Sometimes they are extremely quick and sometimes really, really not. But 4 to 6 weeks to have the IPO decide whether or not your mark is acceptable on absolute grounds, which is, you know, is it descriptive? Does it obey public policy? Is it sort of inherently capable of being registered? And then they will also look at what's called relative grounds. Is there something confusingly similar already on the register? And if there is, they will notify the trademark owner. The trademark is then published in the Trademarks Journal, and there is a period of 2 months from when that mark is published when third parties can object. Now, those objections are based on either the absolute grounds, you know, this mark is descriptive, it is not distinctive, or it can also be based on relative grounds. So I've got an existing trademark that's confusingly similar. I don't want this mark to go through. And you would then enter into the opposition process, which is like a mini court hearing, really. You know, you file your objection, they file their defence, you file your evidence, they file their evidence, and then the examiner will rule on the material in front of him. That process can be painfully slow. I've got some going through at the moment that we opposed them in September last year, and it's still not at a place where the other side have managed to get their ducks in a row. So normally 6 months for an opposition process, but it can take much, much longer. So just to talk a little bit about we've focused on trademarks today, but of course there's other IP rights within your business. You know, there might be copyright in logos, there might be copyright in text, in images, in your website, in design drawings, in business strategy documents, in consultancy documents, in proposals. You know, the list goes on and on. And we need my other workshop really to understand those rights. But when you think about how important IP is within your business, that can be a really good decision for you and a good strategy for you, because then it helps you look at budgets and work out how much you want to spend in order to protect your IP. It can help you look at existing company policies. You know, have I got my employee contracts properly drafted so that any confidential information is retained properly within the business? What sort of budget do I want to put towards my protection? Do I want to get trademarks in the UK? Do I then want to get the stylized version and a logo? What budget will I need? When do I want to do that? And it just, for me, helps you to sort of put tangible boundaries around this beautiful reputation that you've worked so hard to create. You know, why not protect it? You've seen what the fees are. You know, if you do it on your own, you're probably talking about sort of £250, £350 to protect your trademark for the next 10 years. And for me, that's money well spent. And that's it. Oh, it is 5 o'clock. So let me stop sharing that and we'll come back to the screen. I absolutely hate doing it sharing like that because I just can't see anyone. I saw Chris all the way through with his beautiful background. So I was just talking to Chris.
Okay, Laura, we are scheduled to finish at 5, but I do get some stick from Matthew if I let these meetings run on. But it's such an interesting and important topic, and you've given us a great presentation. So if we can perhaps run for another few minutes, I do actually need to personally get away myself for another engagement shortly. But anyway, let's take some questions.
What I was hoping was those slides, by walking you through and ticking the boxes that you would probably tick, you know, keep hold of those slides because you can use them as your reference point if you actually go through and do the trademarks on your own.
That step-by-step guide's tremendously useful, Laura. There's a lot of
good.
valuable information you've given us there.
Rob, will you be sending the slides out?
Yeah, I can make the slides available subject to Laura's agreement.
Yeah, absolutely.
I'll put them on the NFBP website and you can have a link to them. To
be honest, I've got to think about renewing my trademark, but I haven't done it because it was just, I thought it was going to be a bit of a faff.
So the trademark renewal window opens 6 months before your expiry date, and if you don't have an agent acting for you, Caroline, it will come directly to you, and there should be a link where you literally click on the link and it says, do you want to renew? You click yes and they go, okay, we'll take 250 quid, thanks. And it's sort of done.
Yeah, the thing is, I think I need to change it because obviously where I registered it as Food Allergy Training Consultancy and the logo was a bit different. Now I've changed the logo, so I think I'm starting from scratch a bit, really.
Yeah, fine. Well, you know, if you want any help, then I'm more than happy to help.
Thank you, Laura.
So you got a question?
Yes, very quickly. One of the things you said to us, Laura, was that we needed to be able to prove our reputation.
If you are not registering your mark, if you're going to try and rely on an unregistered mark, then it's all about reputation. You know, bizarrely, if you're applying to register your trademark, you don't have to prove reputation at all.